That's fine
motion
with me,
first.
Judge. Well,
Okay. All right, Ms. Rademacher.
thank you, Your Honor. Your Honor, the motion is quite simple, I believe. This court, we had a hearing on August 21 regarding child support. And the court actually encouraged the attorneys to talk over this 415 order. As I came in on this case, I was reviewing it, and it was very clear to me in black and white. The April 15th order says the front of the court recommendation regarding the parenting time is adopted as to all parenting time. To me, all means the entire recommendation. Then the matter was further scheduled for a review to show housing stability. So they were following up with the, after the adoption of this front of the court recommendation. Once my client did have his home that he lives in now, that lease was provided to the court, in fact, even on that day. And we have not been able to move that forward. So I have now had to file this motion. So I'm asking the court to enforce the April 15th order. It is very clear as it's written, and we need to go into that next phase as my client has proven and they've admitted.
All right, guys, buckle up. This courtroom is already tense. The judge calls on Miss Ratmaker, and she wastes no time firing her shot. She argues that the April 15th order was crystal clear. Parenting time must be fully enforced. Her client, she insists, has housing stability and is ready to move forward. The tension builds as she demands the court take action, accusing delays of injustice. You can feel the air shift as she ends. We've proven everything, now it's time to enforce that order.
That he now has appropriate housing. Thank you.
All right, thank you, Ms. Van Dyken.
Thank you, Your Honor. The order was clear. It was the court to review the parenting time in 6 months. Not me, not Ms. Rademacher, the court. And I believe that was the discussion at the August 21 child support hearing as well. That's why the court has set the matter for an evidentiary hearing in November. With that, Your Honor, we are not against implementing the front of the court recommendation, but there seems to be some dismissal about what that parenting time looks like. It's not week on, week off. It's simply Wednesday evenings and every other weekend. Ms. Rademacher made that allegation in her response to my motion for custody and parenting time. We still have hesitation with the things that Mr. Griffin is saying to these minor children, which is part of my motion to change legal and physical custody and kind of withhold some of that parenting.
In comes Miss Van Dyken, cool but firm. She pushes back, saying the order wasn't for lawyers to enforce, but for the court to review. Her tone drips with challenge. She claims communication between the parents hasn't improved and accuses the father of feeding the kids harmful comments. The judge listens closely as she frames this as a deeper issue, not just time, but trust. The entire courtroom hangs on her words. You can tell this is no ordinary parenting dispute.
Time back until he can get the ability to communicate. That was another part of the order, was that it was the ability of the parties to communicate. That's what the referee or this court was going to review at that time. With the things that I placed in my motion for legal and physical custody and parenting time modification, you can see that that communication has not improved at all. So I believe this leaves it up for the court to have that evidentiary hearing to see if that appropriate reinstatement of parenting time is appropriate. Thank you.
Ms. Rademacher.
Thank you. I heard a circular argument there. The bottom line is that the 415 order needs to be implemented. If they wanted to modify that, they could have filed a different motion. Now that we've sought to enforce it, they filed this change of custody thing, which you'll rule on that next. But the bottom line is the review hearing is to review.
Miss Ratmaker fires right back, her voice sharp, her argument tighter than ever. The 415 order needs to be implemented. Period. She says if they wanted it changed, they should have filed a new motion, not block enforcement. She points out that the review hearing was only to see how things were progressing, not to rewrite the entire case. It's a verbal showdown, lawyer versus lawyer, both drawing their legal swords before the judge finally raises his hand to rule.
How things have been going. And so we can't, I agree with Ms. Van Dyken that the attorneys can't unilaterally make those decisions. The court can. That's what the review hearing's for. We need to implement the order as written. It's very clear. Thank you.
All right, thank you. I will grant the motion. However, we are looking at an evidentiary hearing coming up very soon. So at which point the court will review all of it. But I will grant the motion.
Thank you, Your Honor.
Moving on to the motion to modify custody.
Thank you, Your Honor. I believe that we've reached the threshold to have the court take a look at the best interest factors of these children. Again, with the comments that the father is making to these children.
The gavel drops. I'll grant the motion, the judge declares. The courtroom exhales, one battle down, another about to start. Because now, the real fight begins, the motion to modify custody. Instantly, Van Dyken jumps in, pushing hard that the father's words are emotionally harming the children. She paints him as intrusive, unstable, and a threat to their peace. Her tone sharpens, every sentence hitting like a hammer. The judge listens, but his expression stays unreadable.
Clearly affects the children and the best interest, their emotional well-being as well. So it does affect not only that best interest factor, but many others. As for the change of physical custody, Your Honor, while I understand that physical custody is not a statutory mandate, we've always assumed that when the parties have joint physical custody, people think that they have 50-50. They do not. As for the parenting time, we still have the ongoing same concerns about Mr. Griffin's involvement with involving the children in inappropriate comments, inappropriate communication. He's inserting himself into educational endeavors that are not, educational endeavors, and confronting my client at the school where teachers and other adults had to intervene from him approaching her, and they were the ones who asked her that she should call the police because the communication and the involvement between the two parties is hostile at best. We believe that we've reached the threshold, and this court can then look at the same physical, legal, and parenting time when it does its review in the soonest evidentiary hearing in November. Thank you.
Van Dyken's case escalates. She argues that the father's behavior at school confronting teachers, stepping into educational matters crossed a line. He's making scenes, she warns. Other adults had to intervene. Her voice trembles between control and fury. She demands the court revisit custody for the children's emotional safety. The tension is electric. Even the judge, steady as ever, asks if both sides are using the court-approved communication apps. When they both confirm, everyone knows this storm isn't over yet.
Thank you. Are the parties using Our Family Wizard or AppClose or any of those kinds of apps?
Our Family Wizard, yes.
Yes.
I thought so. Okay. All right. Thank you. Ms. Rademacher.
Thank you. Your Honor, I disagree entirely. The parties are using Our Family Wizard. We don't have any attachments as an offer of proof. The parties have communicated regarding, I mentioned their son, LEG, who went through a whole autism assessment. The parties did agree on getting the assessment. They've agreed to the medication. They've attended many IEPs with him. And also CEG has had a little bit of school involvement in IEP type meetings. So there's nothing that has been alleged that impacts a timely decision or parenting of these children other than these parties don't like each other, quite frankly. And that is not a basis for change of custody. They mentioned late exchanges. That is not a threshold. In fact, there's no offer of proof at all. My client indicates he's a very timely person. He does not even understand that allegation. What they've indicated is there's a hostile demeanor by my client. Their pick up and drop.
Ratmaker rises again, and she's not holding back. Your Honor, I disagree entirely. Her tone is fiery. She claims her client has followed every rule, used the parenting apps, attended autism assessments, and cooperated with schooling. There's no proof, she insists, only accusations. She paints the father as consistent and reliable, countering every attack. Her voice sharpens. These parties simply don't like each other. That's not grounds for changing custody. The courtroom buzzes as she dismantles the opposition point by point.
Offs are at Safe Connections. When I was asking, and I mentioned that when I came in on this case, they are at Safe Connections already. When I was talking to them about this allegation, they don't even do the normal exchange that I would have assumed Safe Connections meant. And that's where one party drops off, the kids go in the building and so on. No one informed these people that that's the process. They were just literally meeting in the parking lot at Safe Connections. I wish they would have known better. Now,
If I could just interject, unfortunately, Safe Connections is no longer, they lost their funding. So there's going to have to be something else figured out on that. So I just wanted to interject that.
Yep. I mentioned that in my response. So what we looked at is where Safe Connections were. We think St. Mary's, because it's 24/7, has security and so forth. And we think the parties can just stay in their car. They don't need to be outside of their car, which unfortunately Safe Connections did. But the problem with the children is, I think when I'm reading this motion, is they clearly are becoming reporters for mother. That to me is a red flag that the mother is involving them in regard to this matter. What we do is the remedy is we modify the exchange.
She continues, calling out the false allegations, the supposed hostile pickups. She says they've been happening at Safe Connections, not random spots. But then the twist. The judge interjects, Safe Connections lost funding. They'll need a new exchange site. Without missing a beat, Ratmaker suggests Dee marries with cameras and security. She's quick, strategic, almost defiant. Then she drops the real bomb. These kids are becoming reporters for their mother. That's a red flag. The tension spikes through the room.
We don't modify custody. We need to just clean that up a little bit better. So I do ask the court to allow that St. Mary's exchange. The parent stays in the car with the kids. The other parent pulls up 4 spaces away. The kids are old enough that they can hop into the other one. This alleged incidents at school, my client again was never contacted by teachers, never contacted by police, never contacted by principals. He reached out and we attached that as an exhibit. Was there ever incident? The exhibit, the principal confirmed she looked no incidences in regard to any problems. So again, the offer of proof is insufficient. And certainly my client would have heard something even from the plaintiff. You would think she would have said, hey, what happened today, or your behavior was inappropriate, even on a family wizard. They alleged the drinking as a threshold argument. No evidence of that other than children reporting. We attached his wife little statement as to their behavior, what they do as a family. There's no arguments or offer of proofs in regard to any parenting that's affected the children. They're stable in school, and the only thing that they seriously desire is to spend the time back with dad that they aren't allowed. But thank you.
Voice steadies but still burns with conviction. She argues the mom's manipulating the children, feeding them stories. She denies any drinking issues, any bad behavior, and accuses the opposing side of twisting facts. The kids want time with their dad, she says, leaning on that emotional weight. Every word feels like a strike in a heavyweight bout. Ratmaker reminds the court this exact dispute was already reviewed months ago and nothing has changed since. The courtroom feels the sting of déjà vu.
Or at least granting the first part of that motion. So the bottom line is that Marie Klessler back in April heard many of these same or similar arguments. She granted a review in regard to what she deemed were 2 issues between the parties: their communication and the housing stability. That's all. Nothing else has changed. And we have a hearing date for those 2 issues. So again, I believe that this motion fails in its offer of proof, and even the allegations themselves. Remedies are more addressed to communication and exchange versus a change of custody. Thank you.
All right. Ms. Van Dyken, any response to the change of location for exchange?
Your Honor, just saying a parking lot at St. Mary's is insufficient. I mean, there is a front parking lot by the hospital. There's one across the street. There's a parking structure. There's one in the back lot. I mean, I think we need more specificity with that. Quite frankly, just saying a parking lot is not appropriate. I'm not sure that there are cameras in all of the parking lots, like the one across the street. I think it would have to be in the main parking lot in front of the hospital.
I see Ms. Rademacher nodding her head. So that sounds like...
I'm not sure there are always going to be access to that, because I've been to the hospital where that parking lot is full and you have to go park in the ramp. So I'm just saying, there's gonna be issues.
Issues.
Then comes the debate over the new exchange location. Van Dyken fires back, a parking lot isn't enough. She demands more specifics: cameras, safety, clarity. The back and forth is fierce, yet oddly professional, like two chess players locking eyes before the final move. The judge listens, nods, and lets them hash it out. They agree to scope the STT, Mary's lot together, and find a clear, secure handoff point. The entire room can feel the slow march toward closure, but not quite peace.
Ms. Rademacher, any thoughts on that? That's a fair point.
So, if the exchange is in the evening on Sundays, he would pick up from school on Fridays, so we're good there, and he picks up Wednesdays. And I think, I don't recall what the Wednesday parenting time is, if
Evening.
it's an overnight or just an evening. Let me
It's
see
an
here.
evening.
Weekdays, Wednesday until 7:30. So we have Wednesday night exchanges and holiday exchanges, and Sundays at 4:30. So the only thing I can suggest is, I haven't scoped out that main parking lot lately. But perhaps Ms. Van Dyken and I can look at that parking lot and pick a corner that they can exchange, or maybe even up near the front if there's cameras. I don't know how to describe that, but I'm pretty sure we could figure out where in the parking lot.
Okay, and you probably would need a backup,
Yeah.
Yeah.
is what I'm hearing.
Okay.
A very
And we're not
clear
that-
plan.
We're not that far from the Grand Rapids Police Department on Monroe Center Drive. Perhaps that could be the backup.
Okay.
All right. So what I'm going to do on the motion to modify custody is I am going to set that for the evidentiary hearing. I'm going to adjourn it because I have not been the judicial officer dealing with this case. And I think Referee Kessler is probably in a better position, even though I've read everything, to rule on that. And I'm not, frankly, it's not clear to me either way. So I'm just going to defer and set it at the same time as the evidentiary hearing for her to rule on the motion.
Thank you, Your Honor.
Thank you, Honor. So to make it clear, our evidentiary hearing will proceed as to parenting time, and then Ms. Kessler would rule on the motion.
That's correct.
Okay. And then Ms. Van Dyken and I will confirm the location in the St. Mary's parking lot and back up as.
And a
chair.
backup. Yep. All right.
Can I
Anything
ask one
else?
more question?
Sure.
Do we know whose weekend this weekend would be? And my client's indicating it's your client, so we'll start with his next weekend.
Next Wednesday.
Well, Wednesday, yes, I agree.
Okay.
Yeah.
All right.
and His weekend next. All right, thank you so
Thank
much.
you, Your Honor.
And before we leave, I just want to admonish both parties, do not talk about what's going on here with your kids. They feel, regardless, they feel that they're half and half, each of you. And so any disparaging remarks, any negative comments about the other parent, they're internalizing, whether you think they are or not. It's just really damaging to them. So please don't do it. If you love your kids, don't. Okay. All right. We're adjourned. Thank you.
Thank you, Your Honor.
Okay, thank you.
Finally, the judge rules the custody motion will be deferred to the evidentiary hearing in November. Both lawyers accept, but the judge isn't done. He looks up, voice low but powerful. Do not discuss this case with your children. The courtroom freezes. Any negative talk damages them. Don't do it if you love them. It's a chilling, heartfelt warning that silences everyone.